Let's kick off with business and immigration law updates. This is a presentation of attorney Ramesh Khurana of the Khurana Law Firm, located in Rockville, Maryland. Back to the set, here the moderator is attorney Kenneth Haber, who questions attorney Khurana on green card through marriage. Let's take a look.
Hello, this is the Capitol Forum. I'm Kenneth Haber, former Assistant United States Attorney and former Senior Attorney in the Office of the Inspector General of Health and Human Services. With us today, we have Ramesh Khurana, the well-known international and national immigration attorney that has helped countless number of people become productive residents and citizens in this country. Welcome, Ramesh.
Thank you very much, Ken. I appreciate your nice introduction.
My pleasure, my pleasure. Can we just discuss the green card through marriage today? Can you explain to the viewing audience the general parameters of that? Are there any restrictions in terms of numbers of cards available?
Ken, it's a very wide topic, but I'm glad you asked me a question about availability of specific numbers when a person gets married to a U.S. citizen. I can answer this question by saying that there are no limited numbers. So what we call is that this is the kind of priority under which green card numbers are always available. So this is always current, and there is no quota, no number restrictions like we saw in some other types of visa petitions. If a U.S. citizen is getting married to an alien who is here on any kind of visa, or getting married to a person who is sitting abroad, visa numbers are available right away.
That's good. That's good. I know that when I applied for my wife's green card, we were already married, so I presume that there's no problems with that either.
You know, Ken, in fact, you are eligible to apply for your spouse only when you get married. You know, because if you are not married, if she is your fiance, then you can apply for the fiance visa if she is sitting abroad, because this is your choice whether you want to apply for a fiance visa and want to bring your spouse to the United States and then get married. In that kind of situation, you have to get married within 90 days of the arrival of your fiance.
And if it's 91, you're out of luck, is that
Yes, then you are out of status.
Out of status.
So you have to get married within 90 days. But otherwise, get married. If she's here, file for adjustment of status, or go to foreign country, like if she's in Mexico, go there, get married, come back and apply for it.
Sounds like something that I might have done in terms of filing for adjustment of status. And I had one of the best attorneys in the country guide me in that process.
Wonderful. I'm very happy to know that.
My next door neighbor.
Oh, thank you so much. Was it me?
Yes, it was.
Oh, thank you so much. Thank you. I appreciate it.
Could you describe some of the steps that are involved? You know, I mean, like I know them because you walked me through them, but for the audience, what are some of the steps involved in applying for a green card for the spouse of a citizen?
Yeah, sure. Ken, in the interest of time, I would like to limit my explanation about the options available, but there are two options available. One scenario is that your would-be spouse is available here, or you get married now, she is no longer a fiance, you get married and she is sitting here, so you have to apply what we call is for change of status. If she is on a visitor visa, you file the application for change of status, and after approval of change of status, and it takes nowadays 4 to 6 months, and once the status is approved, then she gets the green card. Now, if your spouse is not here, she is abroad, she is in India, then you have to file what we call the Form I-130, and once the Form I-130 is approved, then this approval will be communicated to the National Visa Center, then process with the National Visa Center starts, and then you have to complete the documentation, you have to ask your wife to send the police report, her birth certificate, and fill in certain forms which are DS 260 to 61, and you have to provide an affidavit of support. That means you have to prove to the immigration department that you will support her financially, so that that person is not going to be a charge on the state. US government doesn't want to take the financial obligation of bringing a person here and then subject to some kind of financial help to that person. So, once you have completed all the paperwork and it is a bona fide marriage, it should not be for the purpose of evading immigration laws. That is very important. You must be reading in the press. Sometimes people do get married just to avoid the implementation of immigration laws, so that a person who is sitting here illegal, that person can obtain the green card. So, that should not be the intent of the person. It should be a genuine and bona fide marriage.
Yeah, you speak of these, and I recall when I went with my wife for the interview to make sure it was a bona fide marriage. And during the interview, my wife and I started arguing, and the immigration officer who was doing the interview said, "That's enough. I know you're married, because no one will get up and argue."
I get your very helpful tape, and whenever I have to advise my clients, especially in marriage-based cases, I would say, don't show any love for each other. Just start arguing.
Start arguing, right?
In order to prove that you are husband and wife.
Exactly.
I like this idea.
Yeah, it was what happened. She just broke out smiling. I said, "I know you're married," because no one else would be arguing like that.
You know, interview is just to determine whether this is a bona fide marriage or not. It's a question of your credibility. Like, how do you conduct yourself when you are sitting there in front of the officer? He just wants to ask you certain questions. Otherwise, you have heavily documented your application. But he looks at your faces, he looks into your eyes, and he says, "Okay, I'm happy." It's a genuine marriage, and green card is given.
That's right. That's right. No one's going to go in front of them and start arguing unless
That's
they're
right.
really married.
Yeah.
Can a U.S. citizen file for a change of status for a visiting spouse in the U.S.?
Again, this is a very tricky situation, because if the US citizen has to file for the change of status of his wife who came here on a tourist visa or B2 visa, B1, B2 visa, so you have got to be careful, because you have to prove that when your spouse entered the United States had no intent to get married. Intent part is very, very vital here. So, I always say, if you are filing adjustment of status application, after 90 days, you are safe. Then there is no presumption that this person had a fraudulent intent. Not that they cannot infer from other circumstances, but there is no presumption. But if a person enters here in the United States within 30 days, they get married, you know, the presumption is it was a fraudulent intent, and that person is going to have a very hard time.
Well, my wife and I, we got married within 6 months. That's pretty close to it.
You are pretty safe. Yeah. And one thing I would like to tell the audience here, Ken, for the spouse, the most important thing is that the person who is coming on a visitor visa should have come through the inspection. That means entry should be legal. It doesn't matter even if the tourist visa is expired. Let us say a person has come for 6 months and she gets married after 6 months, but her entry was at the Washington Dulles airport. So, she came through the inspection by the CBP officer. She is fine, even if she is out of status.
Even if she overstayed, she's fine.
Yes, because she has gotten married to a US citizen spouse.
If somehow how else would they get in here except by going through inspection? You're jumping over a ship,
You know, people adopt different strategies. You and I read in the press, but it's happening. This is a fact of life, that many people have entered the United States without inspection, without entering through legal means. And if somebody has entered through illegal means, even if that person marries a US citizen, he or she cannot adjust his or her status.
If somebody was coming from Cuba and they came over on a rowboat and they got ashore, now they're on shore, they claim whatever status they're entitled to claim because they came from Cuba, they would then want to go to an inspector and submit themselves?
Well, it depends what is their intention to do. If they are going to submit to the inspector for inspection, and if that person doesn't have any visa and no relief is available, let's say that if person already got married and then this entry is illegal because that person doesn't have any visa, that person is definitely going to be in trouble. That person will be sent back under expedited removal proceedings.
Are there any red flags for people that they should be aware of concerning filing petitions for green visas?
Yes.
Green cards?
Yes, Ken, there are red flags. Just to give you a few examples in the interest of time, let us say age difference. The age difference between the two spouses is 15 years. Now, that could kill the case. Now, second would be cultural issues like interracial marriages. Level of education is totally different. One person is holding a PhD degree, other person is just a high school graduate. How they are going to communicate with each other mentally? That's a big question mark, and that's a red flag. And there may be a disparity in income of two people. One person is the CEO of Apple. Other person is just working at the sport level. He's making $1 million a year and the lady is making $7 an hour. So there is this very strong disparity in income. So, not that they cannot get married, but only thing is burden is very high to prove that this is a bona fide marriage. And this marriage is not to evade immigration laws.
It seems to me that they need to become more aware of love, because love conquers all. And
That's right.
The disparities don't necessarily spell fraud.
Yeah, so they have to follow your tip. Fight before the immigration officer.
That's right. That's right. Number one rule, fight before the immigration official, and
Right.
you got it made in the shade.
Don't hold your hands like we love each other, right?
That's right.
So it's all a question of proving if it's a bona fide marriage, no problem. But since your question was about the red flags, so these are the red flags.
Is there any issue concerning pre-existing intent?
Oh, definitely. This issue is very strong, and if the pre-existing intent is immigrant, when you are entering the United States, like you already made up your mind. You planned with your spouse, come here, and there is a loophole in the law. We will get married after 90 days. So your preconceived intent was immigrant. It was not non-immigrant. So you are going to have a hard time.
So it's better to file the petition to bring over your fiance.
You got it. Bring that person as a fiance, or just start the green card process while you are here. And it's going to take some time, maybe 8 months, 10 months, but at least you are taking a very safe route. Your spouse would come eventually.
Very good.
The person is in the queue. These are processing delays, but there is no question of priority date because it's always current. But whatever is the processing delays, after the processing is done.
Thank you very much.
Thank you very much, Ken.
And remember, if you want immigrant status, if you want your wife coming over, have an argument in front of the immigration official.
Yes. Thank you very much, Ken.
Thank
it
you.
has been a great pleasure being here in the studios. And as always, I advise the audience, always consult your immigration issues with an experienced immigration lawyer. Thank you very much for being with us.
Thank you.
Thank you.